Hello everyone and welcome to FAIR's free monthly webinar series. My name is Mike Spigler and I'm the Vice President of Education for FAIR. I'll be moderating today's program. Throughout the talk I'll be taking questions through either the question or chat functions in the toolbar on the right hand side of your screen. We've already received several questions in advance of the webinar, but if time allows we'll take some additional questions at the end of the talk. Today's talk is vitally important to the quality of life of those with food allergies, and based on the number of people who have signed up for this talk, it is serving a great need. Today's presenter is M. Tess O'Brien Heinzen. Tess is an attorney with Boardman & Clark Law Firm in Madison, Wisconsin. She's practiced in the litigation area for 8 years and has provided support in a wide range of civil and appellate cases. Tess also provides legal consultation with respect to issues under the ADAAA, ADAAA, and the Rehabilitation Act. She's also a frequent speaker and writer on this area of the law. It is my pleasure to turn the webinar over to Tess.
Thank you very much. As Mike said, I'm Tess O'Brien, and I'm a lawyer at Boardman & Clark. I think my bio says that I had been in the litigation area for 8 years. I've actually been practicing law for about 20 years, have been in and out of the practice, some litigation, and quite a bit of ADA and disability law. I'm going to talk just a little bit about, before I dive into this, which I know people are wanting to know the law, so I'll keep this part short, just a little bit about my background. I came into this area in sort of a unique way, which I think puts me, and that the risk of her ingesting it may be small if she avoided it, but the fact that the reaction was so severe and could end up in death should have been something the court looked at. So an interesting case, and it really set the stage for food allergies for quite a while before the ADA came out with its amendments. 3 statutes I'm going to talk about today, and these really are the 3 statutes that provide the framework for disability law in general, particularly in school-age children and with food allergy sufferers. First is the IDEA. It's the Individuals with Disabilities Education Act, and that is a grant statute. It provides federal funding to schools, K through 12 public schools, to provide special education. Section 504, which we'll talk a lot about, is an anti-discrimination statute. And that is the same as the ADA, both anti-discrimination. Different than IDEA. IDEA is meant to provide special education. 504 and the ADA are meant to prohibit discrimination. Now, how both of those do those 2 things ends up to work similarly, as you will see. But it's always important to keep in mind that Section 504 and ADA are not special education statutes. They are meant to prohibit discrimination. Section 504 applies to schools and employers receiving federal financial assistance. We'll talk about that a little bit more. That's a fairly broad, particularly with regard to schools, a broad number of schools fall under Section 504. And the ADA applies to public and private schools that are private ones being places of public accommodation. There is an exemption for purely religious schools, and it also applies to employers with 15 or more employees. So let's start out, first of all, with the IDEA. And I'm going to admittedly be a little bit shorter with respect to the IDEA because, generally speaking, food allergies are dealt with in 504 plans more prevalently than they are dealt with in IEPs. But I do want to talk about it because this is a topic that a lot of people ask me about. The IDEA, as I said before, is an affirmative law that requires special education and related services for those who qualify under one of the categories of the law. It's a grant statute. Anybody who has an IEP, who has looked at an IEP, works in the education area knows that the regulations with respect to the IDEA are many. I mean, the regulations are thick. The requirements for paperwork and documentation go way above what you would see with Section 504. The IDEA applies to public school students between the ages of 3 and 21 who are determined by a multidisciplinary team to be eligible in one or more of the categories and in need of special ed. And really the purpose of IDEA is to provide a floor of education, to bring a student up to where everybody else in their level of learning is. So to at least start them out. It isn't to provide the best possible education. It's not there to provide and to allow somebody to get A's. It's to provide really just the basis or the floor of education. How does it apply to food allergies? Well, to be eligible under IDEA, and when people talk about IDEA, it's the documents that you're most familiar with, I'm sure, are IEPs. To be eligible under the IDEA to get an IEP, there are 3 things that you need to qualify. Number one is that to be a child with a disability means you have to have one of these impairments that are listed here on this slide. This list is exhaustive. So unlike Section 504, which has a very broad application and isn't meant to be exhaustive, the idea is this list is exhaustive. So you have to have intellectual disabilities, hearing impairments, serious emotional disturbance, orthopedic impairments. One of those impairments you need to have. The second thing that you have to have is that that impairment has to affect your learning. Again, a different standard under Section 504, because under Section 504 there are lots of things your impairment can affect. It doesn't have to necessarily affect your learning, but to get an IEP, it does. And the third thing to get an IEP is that you have to be someone who's in need of special education. So those three things, you have to have an impairment that falls under the statute, you have to have an impairment that affects your learning, and you have to be in need of special education. Now, where would that fall in for food allergies? You'll see on there that there's other health impairment. And if you would see an IEP with food allergies addressed in it, food allergies would most likely be under the other health impairment. What I generally see in terms of IEPs that address food allergies are students and individuals who have other impairments that you would find under the idea and are in need of special education services. Food allergies is an impairment that's in addition to those. And so they address the food allergies and the accommodations they're going to make in their IEP versus a 504 plan. So generally speaking, food allergy is often unlikely to be the basis for an IEP, although not to say that it can't be with severe food allergies and other things that you may need accommodations with. Potentially food allergies could affect your learning. I mean, we have various examples. But generally across the board, they are mostly dealt with in Section 504 plans. Hence the reason I'm going to spend a good portion of my time on the 504. And if you have questions about the IEP portion of it, we can come back and talk about that. So Section 504 is the Rehabilitation Act of 1973. It's a federal law, as I said, that's designed to protect the rights of individuals with disabilities in programs and activities that receive federal financial assistance. And essentially, it's an anti-discrimination law, and it says no otherwise qualified individual with a disability shall solely by reason of his or her disability be excluded from participating in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So there's the standard. That's the 504 standard. It applies to all public and private K through 12 school districts that receive federal financial assistance. And when I talk about that, and I'll mention the post-secondary education institutions here in just a second too, even though it's not on the slide. Institutions that receive federal financial assistance. People ask me a lot about private schools, and sometimes it takes a little digging to determine whether or not they are required to comply with Section 504. Think about it this way. Most private schools receive some sort of federal grants, either perhaps in free and reduced lunch money, literacy programs, drug awareness programs. You're hard-pressed, really, to find a private institution or a private school that does not receive some federal financial assistance. Not to say that they aren't out there, but generally speaking, when you start to look at the analysis, most schools receive some type of federal financial assistance. Section 504 requires K through 12 districts to provide students with disabilities the opportunity, and this is important, to participate in or benefit from the aid, the benefit, or service in a manner that's equal to and as effective as that afforded others. And this is a standard you see again and again in case law that comes up, in decisions by administrative agencies. Was the individual with a disability able to participate in the programs and in the services and the things that were offered by a school in a manner that's equal to and as effective as others? And that standard is a standard that is argued about a lot with other disabilities, but certainly applicable to food allergies as well. And this is just a restatement of that equal access. I did want to say one quick thing about post-secondary. Section 504 also applies to post-secondary institutions that receive federal financial assistance. There's a difference in that there are different obligations of the post-secondary institution. For example, under Section 504 in K through 12 education, K through 12 institutions have what's called a child find obligation. they have to seek out and find individuals with disabilities and evaluate them to see if they need accommodations under Section 504. So as a parent, you may say, gosh, my child who's coming in has a severe allergy to peanuts. They may not request an accommodation. They may not provide you with anything as a school district. But as a school district, that should trigger then an analysis by you that says, gee, they have a severe peanut allergy. We're having to accommodate them in the lunchroom. We probably need to evaluate them under Section 504. That's different in colleges. In colleges, the person who has the disability, and in this case it would be the individual who has the food allergy, has the obligation to seek out accommodations from the university. They have no obligation to come and find you. So if you have disability and you have food allergies, it is your responsibility to get documentation, and the universities and the colleges have a standard for what they require for documentation, to get the documentation and to take it to the Disability Rights Office and start the process yourself. A big difference. So with equal opportunity, real quickly, for food allergy sufferers, what does that mean? You have to have an equal opportunity to participate in it or benefit from educational aid, benefits, or services. You have to be able to go on field trips and in a way that you can be safe going on them. You have to be able to learn in a classroom that you know that you're going to be safe, that there are going to be accommodations made for you so that you are not being exposed to the offending allergens. If there are after-school activities that are sponsored by the school's obligation extends to those. You have to be able to participate and have an opportunity to participate in those, and have the school, if they're able to make accommodations for you so that you're able to participate. So when you look at the whole host of benefits and programs that a school might provide to students, from the beginning of the day, maybe early morning, all the way to the end of the day and extracurriculars, you as an individual with a disability need to have equal access to those and be able to participate as well. So who does Section 504 cover? And this is the eligibility question. And we'll go back to this question because this is a specific one that changed in 2009 when the law changed. Section 504 covers individuals, and it's three different types of individuals. One, individuals who have physical or mental impairment which substantially limits one or more of their major life activities. And they are entitled to both no active discrimination and FAPE, which is a free and appropriate public education, meaning you have to be able to provide accommodations to them in order for them to get an education. It applies to individuals who have a record of such impairment, and a record of such impairment, you may see that as somebody who over the past several years has struggled with cancer, for example. They've had a record. They are entitled to no active discrimination, but they may not be entitled to accommodations because they may just not need them at that moment. Or three, have been regarded as having such an impairment, and again, they're entitled to no active discrimination. And that's if somebody is regarded as being disabled, you cannot discriminate against them, even if they actually don't physically have a disability. And that the last two prongs of those apply less to food allergy sufferers, frankly, than they do with others with disabilities. So I won't spend much time other than just mentioning those. Section 504, what does it result in? If you are eligible under Section 504, what does that mean? Well, once a school makes a determination that you're eligible, then they say, do we need to put accommodations in place so they can benefit from all the programs and services that we have? And here you talk about a Section 504 plan. And Section 504 plan looks very different for every disability that you have. For individuals with food allergies, a 504 plan may have provisions in there for administering medications, removing certain foods from classrooms, providing alternate snacks. We're going to go into more detail as to just some general things I like to see in a 504 plan of food allergy individuals, but this just gives you a little bit of a framework with it. So that's a 504 plan. Individual health plan, many of you may be familiar with versus the 504 plan. A lot of students currently, and certainly over the last 5 years, schools have dealt with individuals with food allergies with an individual health plan. And an individual health plan is different than a health plan, is different than any other document in that it's a legal document that you sit down and negotiate with the school and does have sort of have the legal buttress behind it. Related services under 504, districts are required to provide related services if they are needed to assist a child with a disability. And generally speaking, a lot of these, as you can see, would be more applicable to individuals with disabilities, other types of disabilities. But this is not an exhaustive list, and there may be related services that an individual with a food allergy has, maybe an aid on the bus. If they have to take a bus into school and they're within the busing district area and the bus company isn't willing to administer epinephrine, then maybe if a student has a severe enough food allergy, maybe one of the related services is that you provide an aid on the bus. As I mentioned, Section 504 also requires districts to provide non-academic and extracurricular services and activities to individuals in such a manner so that there's an equal benefit. So keep that in mind, not just the school day. So let's talk about the brief overview of the Section 504 process. And this is, by all means, a brief overview. The regulations with respect to Section 504, as you will see in 34 CFR, are much more detailed than this. Not as detailed as the idea, but they are very detailed. But this gives you just kind of an idea. The 504 process, someone would make a referral. Now, it may be someone in the lunchroom, an aide in the lunchroom who says, I found out from a student that he is allergic to peanuts, and his parents have never come forward. I think we should make a referral and consider whether or not that student needs a 504 plan. It can be a teacher, it can be a parent, it can be the student themselves. But essentially, once that referral is put in, then the process starts going. What will happen after the referral is that the district will pull together a Section 504 team. And it's assembled of individuals knowledgeable about the student and the results of both appropriate evaluations, accommodations, what the district can do to accommodate a student. You will have a Section 504 coordinator there, because every school has a Section 504 coordinator. Oftentimes, you'll have the nurse, usually an essential part of the Section 504 team. So they will pull together a Section 504 team. They'll notify the parents of the referral and their rights. Oftentimes it's the parents doing the referral. And they'll ask the parents' consent to evaluate and to consider the student for 504. They will then invite the parents and that team to a 504 meeting, where that Section 504 team will sit down and talk about determining eligibility. And we'll talk about the eligibility requirements in a couple of minutes, but that is, at that meeting, they'll sit down and say, okay, do we believe this student is eligible under Section 504? If the student has a disability, if the food allergy does qualify as a disability, then the Section 504 team will determine, do we need to have accommodations in place? Are there accommodations that are needed for this student? And every inquiry is individual, and I cannot stress that enough. I mean, just like other disabilities, children with food allergies, there are all different kinds of food allergies, and individual needs are on a case-by-case basis. And one 504 plan, one 504 meeting does not fit all. I mean, there's a lot of different issues that come up individual to each child. If accommodations are necessary, they will provide notification and consent for accommodations. If accommodations aren't necessary, they will decide that as well. Okay, so that is essentially, in a nutshell, Section 504. Now, I'm going to go back for 1 second here, and I'm sorry to do this to you all, but in the process part of it, I want to discuss this because I know this was a question that came up in some of the questions that came in about medical documentation. Where does that come in? How important is that? What kind of weight does it carry? Can a school ignore it? Here's what I will say. Medical documentation for a food allergy. When you pull together a Section 504 team on a disability, an individual with disability in general, the 504 team will look at things like, for example, if you're claiming, if you come in and say my child has ADHD and may need some accommodations, it's likely that you will have a special ed teacher there, perhaps. You will have a regular ed teacher there. You will have individuals there who've tested the child for ADHD, who've observed them in the classroom. You may have a school psychologist there who's done some evaluating. You will have perhaps a doctor's note and a letter from a doctor saying we've diagnosed them with ADHD. You have kind of a whole panoply of things that you look at in determining eligibility. With a food allergy, when you look at what kind of documentation will assist and aid a team in determining whether a student has a food allergy, I would say medical documentation is really the key. I mean, a doctor who can write on the student's behalf, has tested the student in the standard testing protocol, identifies that they have a food allergy, a life-threatening severe food allergy to these individual foods, what types of reactions they would suspect would happen or may have happened with respect to the student, what types of accommodations are needed. You are going to need that if you're going to go into the food service area and request substitute meals. An indication that this is an allergy, it's not an intolerance. You know, as much as your doctor can provide to the school, when you talk about medical documentation, you want as much information in that doctor's letter. I personally always counsel people to write their own letter, or at least a template of it, to the doctor and say, if you are okay with this, please put this onto your letterhead and send this with me. That way you've covered your bases. I also, frankly, pull out the language from Section 504, and I have the doctor say, this student has an impairment that substantially limits a major life activity. I use the language from the statute, and then I provide as much information as I can. And I think when you talk about, can a school ignore medical documentation, honestly, I don't know what else a school would go on besides medical documentation for purposes of a food allergy. Okay, the ADA. The ADA and Section 504 are construed together. So for purposes of when I talk about Section 504 plans and the rights of individuals with food allergies, the ADA is in 1990. Obviously, it was passed. It was really the first comprehensive civil rights law for people with disabilities. It adopted the 504 regulations, giving the regulations the full weight of a federal statute. The ADA regulations say nothing in these regulations can be construed to provide less protection than what's in Section 504. And when you talk and you look at decisions by courts, you will see that they interchange the ADA and Section 504 all the time. So really, when you construe Section 504, you construe the ADA. The ADA, the biggest change in the law that has come in the last, I don't know how many years now, since 2009, that affects food allergy sufferers was the ADAAA. It has to be the worst name for a law because every time I say it, it's a mouthful. But it's essentially the Americans with Disabilities Act Amendments Act, and it was passed by George Bush. And essentially, Congress, what Congress decided is that courts had been construing the ADA incredibly strictly with an inappropriately high level of limitation necessary to obtain coverage under the ADA. Congress, if you pull the public law, and I think I have that on this slide right here, you will be amazed at how specific Congress was in terms of how displeased they were with the courts and the cases that had been coming down. And they made clear that the purpose of these amendments was to reinstate a broad scope of protection under the ADA. And they also made clear that the changes to the ADA also applied to Section 504 in the Rehabilitation Act. So these regulations went into effect in 2011. The ADA is an anti-discrimination statute. Title II applies to public schools. Title III applies to private schools, places of public accommodation. Religious schools are exempted, and essentially you will see that the prohibition on discrimination is similar to what we saw with Section 504, almost word for word. The ADA covers children just like 504 do, or individuals, I should say, not just children, who have a physical or mental impairment that substantially limits one or more major life activities, has a record, or is regarded. So the ADA looks a lot like. Now, what happened with this change with the ADAAA? It really shifted the focus. It's intended to shift the focus from whether a student or an individual is an individual with a disability to how do we accommodate them. Really push that every case is an individual inquiry, and as you'll see here, OCR came out, and this was the language they used. In most cases, application of these rules should quickly shift the inquiry away from the question of whether a student has a disability and toward the school district's actions and obligations to ensure educational opportunities. So it was a big, big shift. the extensive analysis and sort of the tortured analysis that Land v. Baptist went through in that Eighth Circuit decision we first talked about, really OCR made clear and Congress made clear in its public law that that sort of analysis isn't needed. You don't need an extensive analysis. So the key amendments, and ones that particularly apply to food allergy sufferers, the Act is supposed to be construed broadly in favor of giving coverage to individuals. Congress rejected specifically the consideration of mitigating measures. Now, what does that mean for purposes of food allergy sufferers? In Land v. Baptist, they talked about an EpiPen. You cannot consider the fact that an individual who suffers from a food allergy can be treated with an EpiPen in your analysis as whether or not they're disabled. You can't look at what mitigating measures are available. Medication, EpiPens, other types of mitigating measures, you can't look at that as a consideration when you're determining whether or not someone has a disability. The other thing that you can't do is the Congress directed that an impairment that's episodic in nature, so a food allergy, right? You don't have a food allergy, you don't have an allergy to a food unless you have an exposure to the offending allergen. It doesn't matter that most of the time you are not having a reaction. If your reaction would substantially limit your major life activity when it's active, it's enough to qualify you under 504 and the ADAAA. Those were really two pretty big measures for food allergy sufferers. So 3 steps to determining disability. Do they have a physical or mental impairment? Does it affect a major life activity? And does the impairment substantially limit the major life activity? I personally think there's no question that someone with a severe food allergy has a physical impairment. Does it affect a major life activity? You certainly can come up as well as I can that eating, breathing, learning, all those sorts of activities that are listed under the statute are activities that food allergy sufferers deal with when they have an offending allergen. And does the impairment substantially limit? There is no definition for substantially limit in the new regulations, but essentially you say, okay, does it substantially limit in comparison to someone else in the general population? If the kid sitting next to your child who doesn't have a peanut allergy, if my kid is more substantially limited than they are, they're substantially limited. So let's talk about once you have eligibility established, what's the best process to follow? Once the school district has determined that you are eligible under Section 504, here is what I tell people. I say, walk through your student's day in your head. They walk through the front doors of the school, and they walk out of the front doors of school at the end of the day. Where do they go in between? Okay, they walk through the school doors. They walk into their classroom. How are you going to deal with kids who are coming in off the bus or from home that have eaten peanut butter? Well, one way to deal with it certainly would be every kid wash their hands as they walk into the classroom. Provide wipes as children walk into the classroom. Now they go from that classroom to the computer lab. How do you deal with that? Is there any special accommodations needed at the computer lab? Are those keyboards wiped down frequently? Is your child's keyboard wiped down frequently? So they provide wipes to your child in that room. How are they going to deal with their EpiPen as they go from place to place? With respect to how are they going to carry it? Are they going to keep it in a fanny pack, which is generally speaking what a lot of kids will do is keep it in a fanny pack and hang it on the door, hang it on the hook of the door of each classroom, or provide it to an aide as they go out for lunch? So how are those sorts of things going to be dealt with? Ask yourself, could my son or daughter be exposed to a food allergen in the homeroom, in gym, in lunch, in math? Make a list of dangers in the school. Make a list of how you think your student might be best accommodated and by whom. Who's the best person to do this? Will the teacher be with them? Will there be an aide with them? How do we do this? Now the last two, be reasonable and start small. I caution with these two things, and not always the most palatable thing to hear. But I will say that keep in mind that you do, frankly, don't trust it well enough, and I think that it's to ask for those and to read those through yourself. Buses, can they put no eating policies on buses? Could there be an assigned seating so that your child's up front so you don't have to worry that someone's eating in the back? Are there cleaning protocols the bus company is willing to put in place? Again, two-way communications. Extracurricular after-school activities, posting signs on the outside of school saying, we have kids with peanut allergies in here. Please keep in mind that these classrooms are peanut-free. We encourage peanut-free snacks and follow the protocol of the schools. Promote allergy awareness. The storage and transportation of the EpiPen, we talked about that. These are just really a very small sampling of what you might see, but definitely helpful starting points. As I said, it does cover sort of where your child walks in from the morning until where they are when they leave at the end of it. Before I go on to employers, which I will in just a minute, the one question I did want to address and go back to a little bit is you talk about Section 504 plans, and people will frequently ask me, well, should my child have an IEP instead? Isn't an IEP better than a 504 plan? And as we talked about before, and I didn't hit on specifically the differences, a student, generally speaking, if they have a number of health impairments and they have a food allergy as well, that will generally be addressed in an IEP. Could they also have a 504 plan? Well, technically they could. Most often they do not. Now, in terms of both the IEP and the 504, both of these are legal documents. And I've had people ask me that too. A 504 plan isn't a legal document, is it? It is absolutely a legal document. And so is an IEP. But remember, to get an IEP, you have to have an impairment. It has to affect your learning, and you have to be in need of special education. And most individuals who only have food allergy their life activities that are impaired aren't necessarily learning, and they aren't necessarily in need of special education. So they don't qualify for an IEP. But that doesn't mean that a 504 plan isn't just as good. The accommodations that they provide under a 504 equally as good as an IEP. An IEP is really meant to address progress in learning and education. It's why it's the special education statute. So I like to hit on that just because I know a lot of people have those questions. Two things, again, before I go on to Section 504 and employers, two more things, and then I promise I'll get on to that. There are two documents, the OCRs, FAQs, I do want to point out are so helpful. And all you have to look at if you're a parent or an individual out there who has food allergy sufferers, OCR is the Office of Civil Rights. If you Google Office of Civil Rights and either food allergies, the ADAAA, you will come up with these documents. And they provide just a well of information, really, really helpful information for parents out there. Okay, Section 504 and employers. Section 504 does not apply to all employers. It applies to employers and organizations, just like schools, that receive federal financial assistance from any federal department or agency. You might see these that include hospitals, nursing homes, mental health centers, human services programs. Those are the employees that Section 504 cover. The eligibility, the same. Section 504 protects qualified individuals with a disability. And you will look at how individuals with disability is defined under Section 504 in the same manner as we talked about with respect to students. Title I of the ADA applies to employers with 15 or more employees, and it prohibits discrimination. Title III applies to places of public accommodation. Now remember, your state laws out there may be applicable to employers with even less employees. In Wisconsin, where I'm from, the WFEA, or the Wisconsin Fair Employment Act, covers employers with one or more employees. So the state laws may be even stricter than the federal laws. So keep that in mind as you are and what your rights are. The ADA issues in the employment setting arise in a variety of contexts. You may have an employee who requests an accommodation, so it's recognizing that request. We like to call it pursuing the interactive process then with an employee, which includes determining whether they have a disability and how you are going to address the reasonable accommodations that are requested. Real basically, your requests do not need to be in writing. There's no, in the disability laws, there's no terms that need to be used. There's no magic language required. You can request an accommodation to an employer without any special or magic terms. And generally, employers, generally speaking, should not be asking employees if they have disabilities. So you really do want to go and request from an employer an accommodation and tell them that you have a food allergy and you need accommodation. Determining whether an employee has a disability, we talked about that before, what the steps are. But unless the disability is obvious, the employer can request information from the employee's healthcare provider. So the employer can say, I need documentation about the food allergy. And I also need your doctor to tell me how that functionally limits you in the workplace and what reasonable accommodations might exist. So similar, really, to what you see in the schools. An accommodation in the workplace is a change in the work environment or the way in which things are customarily done that allows the individual to perform his or her position and to enjoy equal employment opportunities. This is where this differs a little bit in terms of employment and school. In schools, there is no reasonable accommodation requirement because under Section 504, you're required to provide an individual with a disability a free and appropriate public education. If that, your question is not, is this a reasonable request? If the request is necessary for that child to receive an equal education, it's necessary. In the employment venue, an accommodation is reasonable if it's effective and doesn't cause the employer undue hardship. So there's an undue hardship standard in the employment arena that you do not see in the school arena. Accommodations for food allergies in the workplace. Ones that you might see requested, keeping certain foods out of the workplace, allowing absenteeism for medical reasons, restricting food at office parties, certain ventilation protocols, cleaning protocols that are in place at the office, all reasonable things. Accommodations you can't ask for, long-term lowering of job standards, bumping another employee out of the job so that you can take it because it's more suitable with your food allergy. Repeatedly excusing prohibited behavior on the job, indefinite leaves of absence. And again, measures that cause an employer undue financial burden. What's undue financial burden? It can be a monetary burden, but it also can be a significant operational disruption. So you look at both of those things if you are both an individual who's seeking an accommodation and an employer as what may be required. An employer may look for an employee's physician. You may want to get your physician involved. It's instructive to an employer as to what the physician suggests. And the employer, remember, just like a school district, when you're negotiating a Section 504 plan, an employer is able to choose among a number of reasonable accommodations. You aren't able to walk in and say, this is the only accommodation that will work for me. If there are others that may work for you, an employer is able to choose those if it works better for them. It has to provide you with the accommodation, but what the exact accommodation is, it can vary, and an employer can choose among reasonable ones. Okay, frequently asked questions. Should I go through the frequently asked questions here? I suspect, do you want Mike to?
Yeah, we got the
that came on.
Yeah, I think those are still good. A lot of those
okay.
We have there.
So let's talk about these. The first one, a huge question that comes up all the time, and people ask me about the airline. This is a tough one, and I can't tell you that I can give you a really great answer. You may know the history behind this, but the airlines on an airplane is not regulated by the ADAAA, but it is regulated by the Air Carrier Access Act. Interestingly enough, when you look at the ACAA, it does prohibit discrimination of individuals with disabilities, and individuals with disabilities is defined in the same way under the ACAA as it is under the ADAAA. I just haven't seen any cases out there that have been successful in a suit or in a challenge to an airline based upon the ACAA. I have seen cases out there that have gone under Section 1983, under legal theories of negligence, all unsuccessful. So whether or not if someone launched a challenge under the ACAA on the basis that it's discrimination to serve peanuts on an airplane or not make accommodations for a food allergy sufferer on an airplane, a good argument may be made. You know that the Department of Transportation has tried a few times to put regulations in place with respect to particularly peanut sufferers on the plane. I mean, that's the big one, right, with people opening peanuts and serving peanuts on the plane. The first time they did it, they were shot down, where Congress said, we'll cut off your federal funding if you actually impose these regulations. DOT a couple of years ago, since they hadn't seen that federal language come up for a long time, decided they'd give it another kick at the cat and try to open it up for public hearings and comments on whether or not they should impose a ban, a buffer zone, what they should do. And again, ultimately at the end of it, must have been put in their place because ultimately decided that they would take no action at all and leave the regulations as they were. So the long and the short is, what's your recourse? Certainly, I think someone has an argument that an airline does have to accommodate you as an individual with a disability. Where that goes, I don't know. My suggestion for purposes of airlines would be research the airlines well, which FAIR can help you with and give you a lot of the airlines and their policies and procedures. Can we request our school to be peanut and tree nut free? I think it's an unreasonable request, and I'll just say that right out there. I think it's an unreasonable request in that a school absolutely doesn't know who comes through their borders every day. School groups are using it. Extracurricular activities take place there. Sporting groups are using it. It would be almost impossible for a school to say, we are peanut and tree nut free, mostly because I don't think they could ever guarantee that. I would never counsel someone to ask their school to do that. I think you want the school to be diligent in its efforts, but you also want to recognize that in areas of the school, people may be coming in with peanuts and tree nuts without knowledge of the school. So I think requesting the school to be peanut and tree nut free is not a request that's either practical or makes sense. We attend a private school. Does the ADAAA or Section 504 apply to our school? The answer to that is maybe and yes. Section 504 applies to your school if you receive federal financial assistance. If the school receives federal financial assistance, and as we talked about that, we talked about the fact that many, many schools receive federal financial assistance, and so ultimately, in a practical sense, it applies to many. ADAAA applies to private schools. Does it provide a 504 plan? No. Are they required to accommodate individuals with disabilities? They are. Is there a reasonable accommodation? I addressed this earlier. Is our school required to have a food allergy management policy? No, it's voluntary. I have been doing those policies for schools, though, which I think is a good sign in terms of schools are being very diligent and very aware of food allergies in their schools. Can a school make changes to an existing 504 plan without our consent? As far as what I would say to this is a major change to your 504 plan. No, you need to be part of that. You need to be part of that conversation and the consent given to providing the accommodation. I hedge that answer though a little bit on schools are constantly tweaking things and procedures and the way things work in schools on a day-to-day basis. So if it makes more sense to have an aide follow your student out versus some other situations, or it makes more sense to have your child sit at one table versus the other. On any given day, I think schools do have to have some ability to make kind of day-by-day tweaking and changes to a 504 plan just to make sure to keep your child safe. And I think if you were going to look at that closely and you actually filed a complaint that your school had changed it, I think a court or OCR may look really carefully at it and say, okay, was it a change because they thought it was needed to keep your child safe and accommodate them in the school? And if it is, then I think they may have an argument for doing it. So that ends my frequently asked questions. I think we are pretty close to the time with maybe about a couple of minutes left.
Yeah, so we have never received this many questions before, so I apologize if I didn't get to respond to everyone as I was furiously typing away. But maybe we can just maybe do 2 or 3, and then
Sure.
Tessa's graciously provided her email address at the end as well, which will probably kill me for reiterating, but
Right.
that will be there as well. So a couple questions. Can you just touch briefly on FERPA, the Privacy Act?
Okay, and touch briefly on FERPA. Yeah, so I mean, I don't, generally speaking, the FERPA governs, in case you don't know, student records. And touching briefly on FERPA and how that would apply, certainly there are going to be limitations that FERPA has on what type of information the school can share. So for example, FERPA comes into play when you're putting together a food allergy plan or a management plan. Can you put up a notice in the cafeteria area where the workers work with your child's name, their food allergy, and their picture on it? Well, you'd certainly have to comply with whatever student record requirements and privacy requirements there are in FERPA. So school districts would definitely want to consult a lawyer or somebody who's knowledgeable about what the requirements of FERPA are. As far as touch on it, I don't know what to say more than that, other than FERPA has an unbelievable list of requirements in terms of student records. What are student records? What qualify as student records? Where student records are kept? What the repository for student records are? Who's entitled to see health records? Who's entitled to see psychiatric records? What records are parents have to give consent to sharing? What happens if a student leaves the school and goes to another school? What can you share? So to touch on FERPA would be, a specific question on it would be difficult in itself, but to touch on FERPA, I think, is a tough one.
Okay. So we've had multiple questions regarding what laws protect parents. So for parents of kids with food allergies that have a disability, does ADA in any way apply to them? Would FMLA apply to them if they need to take off work to care for their child, to go in for an emergency, to extra appointments?
Right. So what you're saying is that the parents themselves don't have a disability.
Correct. It's just regarding the child's disability.
Correct. You would look to the employment laws, certainly. I think you'd look to the FMLA. There's actually a couple of cases out there that that they applied the standards under the ADA to a parent's request to take off work to a child who had broken her legs. I think that's if I'm remembering the case correctly. There was a girl who broke both of her legs. The parent had made a request, I think under the FMLA, or maybe even the ADA, for time off. And the question was, could you look at the analysis and apply the analysis of the ADA to the parent, which is exactly the question you're asking. And they did. They said, well, this daughter had a disability under the ADA. She was disabled. Under this ADAAA, the new eligibility standards, she was disabled. And that was what they looked at for purposes of determining FMLA coverage, I think. So certainly I think the analysis that goes into play may go into play in some of the other federal laws. But does the ADA say if your child has a disability, the parent is allowed to miss work for 2 weeks? It doesn't.
Mm-hmm.
So, I mean, the ADA applies to individuals with disabilities. It doesn't apply to their caregivers. It doesn't apply to their parents. You would look to the employment laws to do that.
Multiple questions, and I know this is a bit of a tricky question, but lots of questions about religious schools. And those that receive federal funding, how would someone go about finding out if they receive federal funding? I know it's not necessarily easy.
No, I mean, I think you can go in, frankly, and just request it in a letter. I mean, I guess I would, whatever your requests are, I would put them in a written form and ask to see whatever, and I guess I'd ask that exact question. Please list all of the federal funding you receive in a year or have received over the last 5 years, including monies in grants, monies in any federal programs, literacy programs, that I would ask that to begin with. And schools, I think, would have an obligation to tell you in their public bodies, and I think they'd have an obligation to tell you what funding they received. Beyond that, you could do a formal FOIA request, and ask them for a formal records request to them. That would be another way to get it. I guess those are the two ways that I would say.
And one related question, and then we'll wrap up. Someone asked a question that they have a 504 plan. I'm going to put your email up here now. I know you're going to come with them.
Do it real quickly.
Someone asked a question. They have a 504 in place right now, and they're changing school districts. They're moving.
Okay.
What's the process of getting that 504 plan to a new district?
That's a good question. And I can't tell you right off the top of my head because the regulations, I know the regulations of IDEA apply to that. When you change school districts, what has to be in place. So if you have an IEP, for example, and you move school districts, the school district still has to provide you with FAPE until they have it depends on you're an in-state or an out-of-state school, but they have to provide you with a free and appropriate public education and those accommodations until they can evaluate you themselves. I would say it's likely Section 504 has that same requirement, but I guess my suggestion would be is to, one, talk to your school district and ask them what they would suggest, but two, I would send ahead your 504 plan to whatever school you're moving to and say, we'd like to trigger the evaluation process immediately. Here's our current 504 plan. Please let us know what other documents you might need.
Okay. So thanks again, Tess, for a great webinar. Based on the number of questions I got, you certainly held people's attention very well. I think I gave myself carpal tunnel trying to respond to all of these questions on here. So,
and I will make one more statement real quickly. I'm happy to answer questions about basic areas of the law. I cannot give legal advice. I only practice in Wisconsin, so to answer specific legal questions in different areas of the United States, I'm not able to do, but I'm certainly happy to explain the law.
Thanks, Tess. So you'll be able to view the recorded version of this webinar on our website in about a week, where you also find all of our other recorded talks. If you're interested in learning more about this topic, I would encourage you to attend. Our first National Food Allergy Conference is in Chicago in June, from June 21st to 22nd. Among other great sessions, one feature piece is a 4.5-hour seminar that's been tailored for food allergies, specifically from a disability attorney, Pete Wright, and that's included with the price of admission. To talk about just next month's webinar, it will feature Dr. Ruchi Gupta. Dr. Gupta will be talking about the epidemiology of food allergy and will be providing us with some of the statistics about how many people have food allergies, the characteristics of those who may be at higher risk, and data on the impact of food allergies on families. Member registration will open on Monday, March 17th, and full registration will open on Monday, March 24th. Thank you very much for your time. Again, slides and the webinar will be up on our site in about a week. Thanks again.